Kia ora koutou. Good afternoon, everyone from Lower Hutt, or good morning to our Australian guests. My name's Sarah Bell, and I'm a project lead and senior researcher at the Helen Clark Foundation. Welcome to today's webinar entitled Yes Means Yes, Updating the Definition of Consent in Sexual Violence Law. A particular welcome to our new members or guests who are joining one of our webinars for the first time. If you're not yet a member and are keen to support the Foundation's mission of developing solutions to New Zealand's long-term challenges, we'd love to have you join us. Victoria will put a link in the chat if you'd like to sign up or just learn more about the Foundation's work. Also, a special welcome to those who've joined us today from the sexual violence sector, and a huge thank you for the essential work that you're doing to prevent and respond to sexual violence. Before we move on to today's webinar, a quick plug for our next webinar, which is a week from today on climate change policy issues. That webinar was pulled together by one of our honorary senior fellows, Jonathan Boston, and features Rod Carr and Kay Harrison. You can register for that on our website. We'll also be launching our second report on social cohesion in New Zealand at the end of this month, so keep an eye on your inboxes and in the media for that one. So on to today's webinar. First up, our standard reminder, this is a webinar, not a normal Zoom call. So your cameras and microphones are off and you're safe to eat your lunch without being seen or heard. We'd love for you to participate in the webinar though, and the best way to do that is to submit questions for our panelists by typing them into Zoom's Q&A function, which you can find at the bottom of your screen. Later in the webinar, I'll put the questions to our panelists. You'll see there's also a separate chat function down the bottom. Victoria will be using that to paste links during the webinar, and you're welcome to engage with each other there, but please do put your questions for the panelists into the Q&A area. Just a little word of caution, as you will have gathered from the topic, today's webinar discusses issues of sexual violence and sexual harm. If you're feeling uncomfortable, you can obviously leave at any time, and please do make sure you seek support afterwards if you feel you need to. So today's webinar follows on from the Foundation's report on addressing sexual violence in Aotearoa, funded by the Clare Foundation, which was released in December last year. The report looked at some areas of law and policy where there were gaps with best practice and where there was potential for cross-party consensus to make change. You can read the full report on our website. And the report identifies 4 key areas for practical, meaningful and lasting change. The first is closing the gaps in the justice system to reduce underreporting of sexual violence and increase the number of cases continuing to a trial and a verdict. The second is updating the definition of consent in law to an affirmative or yes means yes consent model, and that's what we'll be talking about today. And the third is addressing the harm caused by sexually explicit deepfakes, and the fourth is eradicating the practice of virginity testing in New Zealand. The work on consent law reform was led by Professor Anna Hai, who's here with us today. Anna is Ahurangi Professor at Otago Whakaihu Waka and was lead author of the consent reform chapter of our sexual violence report. Anna's research reflects expertise in a range of interest areas, including sexual violence, evidence law, and mindfulness pedagogy. Anna is co-director of the Otago Centre for Law and Society and has served on various national evidence law-related committees and faculties. Anna's joined on our panel today by 2 other experts on consent who also contributed to her research for the report. Professor Melanie Barish is an internationally recognised scholar in gender, sexuality and sexual violence prevention. Her research explores the meaning and communication of sexual consent, the social norms that shape intimate relationships, and strategies for preventing sexual violence. Melanie leads applied research on whole campus models for sexual violence prevention that integrate policy, education, and support services. And Dr. Rachel Bergen is Senior Lecturer at Swinburne University of Technology in Melbourne and the Chief Executive Officer of Rape and Sexual Assault Research and Advocacy. Her research has shaped Australian debates and reforms in sexual consent law, child support systems, and family violence risk assessment, with impact spanning law, policy, and frontline practice. We're thrilled to have all 3 of you here. That's enough talking from me. I'm going to run through some questions for our panelists, and then we'll have some time at the end for that Q&A from our audience. We do know our audience has really mixed level of experience with the issues we're talking about today. So our panelists will try and keep the content accessible for non-experts, but hopefully still really useful for those of you who are working in the field. So I'm going to start with Anna. Can you tell us what New Zealand law currently says about consent and explain the changes that we recommended in our report?
Kia ora koutou, kia ora Sarah. Thank you for the introduction. There was a comment about the sound in the chat, which I assume is being looked at, but I'm hoping you can all hear me okay. Yeah, so consent has really come a long way in our sexual violence law. part of my work is looking back and tracking the evolution over time. And you don't have to go too far back to see some really problematic constructions of consent in law. So we have case law from as recently as the 1980s saying that consent can be tearful, reluctant, or indeed unwilling, as oxymoronic as that sounds. These days, juries are instructed that consent must be true consent. It must be freely given by a person in a position to make that decision. Another common instruction is that it must be full, voluntary, free, and informed. Those are all really important, but we actually don't have a definition of consent set out in the Crimes Act itself. What we do have in the Crimes Act is what I would call a negative definition. We have a list of what does not amount to consent. So, circumstances where legally there is no consent. That was added in 1986, which is when we last really substantively reformed the law here. It's a really important list. So it specifies, for example, that a person does not consent if she or he or they are too drunk to consent, or if they're unconscious or cannot consent due to an impairment, for example. Crucially, that list also provides that a person does not consent just because they do not protest. And that was intended to be a break from the common law. Our historical approach to rape was to say, it's valid to just assume or infer that someone's consenting based on the fact that they didn't protest, they didn't fight back. And that was known as the resistance requirement, really problematic, I think, for reasons that will be apparent to all of you, including, of course, the issue of the freeze response, tonic immobility, power dynamics that can be at play, and so on. So we've had some important reform, but we haven't gone all the way towards saying consent must be communicated, which I think is an important change. So we're recommending three really key things. The first is to add a definition, to have a positive definition in the Crimes Act, to make it really clear that consent is free and voluntary agreement. The second is to specify that consent must be communicated externally to have legal effect. Now, that's not to say it has to be enthusiastic or it has to be, using certain words, checking a box. It's still about whether there's true free agreement. It can be communicated, verbally or non-verbally, but to say that it must be communicated to have legal effect is really important. It's commonly known as affirmative consent. And really related to both of those, a small but significant change to the mens rea or the fault element. So this is the state of mind of the defendant. So on that point, we're recommending that the law should provide that whether the defendant did or said anything to ascertain consent. So in other words, whether they communicated about consent should be expressly provided as relevant to whether we think their consent in belief was reasonable. So those are the three key changes. They're not particularly radical. We're already most of the way there in terms of consent as something communicative, but they're really simple and they bring us into step with jurisdictions like Canada and Australia, which have already legislated for affirmative consent.
Thanks, Anna. So Melanie, moving to you now, because I know your work looks a lot about how people communicate about consent. Why would a law change like this matter? What are some of the key issues around how consent is understood and communicated now, and what would be different about that if the law changed?
Kia ora koutou, and thank you, Sarah. Um, I think as Anna kind of alluded to a little bit, what this law change would do is actually bring the law more in line with a lot of growing social expectations and norms around consent. If you haven't read it yet, the report is, I think, quite helpful and quite useful. And one of the things that it points out is that even the police, when they put up videos, educational videos about understanding consent, they're actually also presenting a version of consent that isn't accurate with existing law and that creates a bit of a higher standard for consent than what's currently written in the law. And so I'm from Canada, so that I've got that as a kind of a frame of reference as well. And Anna mentioned Canadian consent law that was changed in 1993 to what is an affirmative model of consent. And so I think that really New Zealand is behind the times. And as Anna said as well, this isn't sort of earth-shattering by any stretch. It's really just bringing consent law and legislation into what the growing social norms around consent are. When I show often when I show students that I work with the definition of consent, often they're quite shocked and surprised because it's not what they were taught at school. It's not the version of consent that they thought, because they do often use the word enthusiastic, and not that I think we're suggesting it that the law should adopt enthusiasm as a standard, but still that they're quite surprised that the legal definition isn't nearly as strong, I think, as it could be. In terms of meaningful changes, what I think, and if I'm thinking back to the work that I did in Canada as a crisis worker and as an educator, and I think where the law was really helpful there was in sort of two places. And one is in terms of working with survivors. Often when they came in, it was quite common. I worked at a university center and they'd come in and they'd say, well, I'm not sure if this is where I'm supposed to be or not, but here's my story. And often showing them the legal definition of consent as it was written was actually really helpful for them to make sense of their own experiences, even if, and most of them didn't report formally to campus or to the police, but it was really important for them to kind of see that the criminal law in our jurisdiction was also being really clear, that what happened to them was not okay. And in terms of education, consent law was actually the point where we got the most pushback, which I think is really interesting, although that was often around intoxication. And I still hear the same from students today around, well, if two people are intoxicated, does that mean that one could charge the other? Each one could charge the other one with sexual assault and that sort of thing. But this notion, even at the time, which was in the mid-90s, that consent had to be free and voluntary and free from power relationships was not contentious. And so, yeah, I think that we just need to move in line with where we're moving socially.
Great, thank you, Melanie. And that flows really nicely into what I was going to ask Rachel about, which is what other jurisdictions are doing. So we often look when we're doing this kind of report and when policy is being made in New Zealand at what countries with similar kind of systems and cultures are doing. So, Rachel, could you talk us through the consent law landscape in Australia and what has changed and been changing?
Yeah, absolutely. Thank you, Sarah. And I'll just start by acknowledging that I'm calling into this webinar from the lands of the Wurundjeri people of the Kulin Nation, and sovereignty was never ceded. So this is always was and always will be Aboriginal land. Um, the consent landscape has shifted quite significantly over the past few years in Australia, and I think it's not necessarily a set of isolated legislative changes, but really a response to highly visible failures of the law and how it was operating in practice. And that modern conversation around consent law reform was prompted in Australia in 2018 by a young woman named Saxon Mullins, who is the survivor of a high profile sexual assault in New South Wales. And she endured two criminal trials in New South Wales for the rape she experienced. In the first trial, the accused, Lazarus, was convicted by a jury. That was overturned when the judge erroneously directed the jury about consent. In the second trial, the judge erroneously, a judge sitting alone, acquitted him, but erroneously applied the law of consent. And that legal error was recognised by the Court of Appeal, but the court refused a third trial because it would be too onerous, or they determined it would be too onerous on the accused. But that's a bunch of errors around the issue of consent, which really highlighted the confusion, even within the legal system, about what consent meant at law. Um, and Saxon Mullins then made the decision to waive her right to anonymity to publicly call for consent law reforms. And I think that moment genuinely shifted the dial nationally around conversations about sexual violence generally. and exposed, I suppose, in really concrete terms, how consent law could accept that someone wasn't consenting, yet still completely fail to deliver accountability because of the way consent law and, this reasonable belief in consent actually operated in practice. Um, but I think it's also important to say, particularly just based on the comments of Anna and Melanie there, that that didn't really occur in a vacuum. Even before 2018, when Saxon spoke out, some Australian jurisdictions already had elements of what we now call affirmative consent, but typically in really limited ways. So to take Victoria for example, consent was defined as free agreement as early as 1991. Um, if memory serves me correctly. It also legislated a non-exhaustive list of consent negating circumstances, like the ones that Anna was referring to, and introduced jury directions on consent and was the first Australian jurisdiction to do so. But it wasn't up until 2007 that mistaken belief in consent had to be reasonable in order to be exculpatory. Before that, there was no requirement of reasonableness. And even in 2007, when that sort of next round of reforms came in Victoria, there was no requirement the accused took any steps to ensure that they had consent, which again, as Anna highlighted, is a really key aspect of affirmative consent. And New South Wales, which is really the jurisdiction that prompted that conversation because it's where the Lazarus case was, took a similar approach to the Victorian model. Tasmania, by contrast, had legislated affirmative consent, I suppose, much better and much earlier. And in 2004, it legislated that model by ensuring that mistaken belief in consent that's not honest or reasonable is not exculpatory, and reasonableness was determined based on many things, including intoxication, recklessness, and critically, that requirement to take steps, to take reasonable steps. Um, I think that in Australia, though, the real acceleration occurred after, as I said, after Saxon's case. And New South Wales reformed consent laws in 2021. It's those reforms significantly pushed other jurisdictions to act, and in many respects to model their reforms on that New South Wales approach, which has been what sort of happened. What's particularly important about the New South Wales reforms is the shift in language and in concept. So consent is framed as free and voluntary agreement, and belief is in consent is not reasonable if the accused did not say or do anything to find out if the other person consents or not. So, in other words, they have to take active steps. And that language around say or do anything, it matters and is really important here. And it comes directly in the wake of the Lazarus case, where the Court of Appeal determined that steps is a broad term and could include merely turning one's mind to the issue of consent, um, and whether or not the other person might be consenting, but not actually seeking to confirm. That would be suffice. So the move to saying or doing something is a deliberate response to that problem. Um, and so I think that, comparatively across Australia, there are some fragmented and inconsistent reforms. There are jurisdictions that have a significant way to go to achieve affirmative consent. But there is a shared trajectory. Again, different jurisdictions within Australia at different places. But I think that trajectory has really been powerfully shaped in Australia by Saxon's case and her advocacy after that. And I suppose most recently, the Australian Law Reform Commission did make some recommendations about harmonisation. But that was again, very narrow, and they stopped short of recommending that everybody have affirmative consent, and that affirmative consent looks like free and voluntary agreement, a requirement to take active steps, and instead those harmonisation recommendations were really about those circumstances in which there is no consent. So it was sort of a limiting, a limited endorsement, I suppose, But overall, that's really the trajectory in Australia. But we're a patchwork in terms of who's where at the moment.
Thanks, Rachel. That's really helpful. Anna, I'm going to move back to you, and I see someone in the chat has asked if we could just reiterate the kind of wording for affirmative consent. So maybe if you could start with that by just outlining what we're proposing that the law say, and then could you speak to whether the changes that we're recommending would mean a defendant has to prove that the complainant consented, or or that the defendant asked about consent? Does this should shift the burden of proof onto the defendant?
Thank you. Thanks, Sarah. And just in light of Rachel's excellent comments and review, I just wanted to, yeah, Tautoko and Saxon Mullins and all of the people who are working in this field as survivors and who are speaking out. It's really you can't really understate the impact that that had on the shape of things in Australia. So um, yeah, it's a great question about the definition. Part of the confusion around affirmative consent, and it relates to Sarah's second question about burden of proof, is you have this concept of affirmative consent, which is used really differently by different people, and it's used differently in terms of the precise doctrinal kind of mechanisms. And I've reviewed that in a lengthy Sydney Law Review paper if anyone wants to read that. But what we're really looking at is the unifying feature of what I call an affirmative consent jurisdiction is that consent is something that has to be externalized. It has to be communicated. You can't say, well, I just inferred it based on, the failure to fight back or, the fact that she didn't say no. Generally in Australia, that has, as Rachel said, meant free and voluntary agreement that is communicated in words or actions. And that the defendant also communicated in terms of taking steps to ascertain. Now, different jurisdictions do it differently in terms of whether um, I won't go into the technicalities, but there's quite a few different ways of doing it. Uh, I also wanted to note, coming from Rachel's comments, that like New Zealand we were in some ways really ahead of the time. Rachel mentioned, the fault requirement, the mens rea of sexual assault is showing that the defendant did not honestly and reasonably believe in consent. But that reasonableness requirement came in fairly recently in the history of rape law. And prior to that, you could simply say, no matter how unreasonable your belief was, if it was honest, that was exculpatory. New Zealand shifted to reasonableness in 1986, so we were really far ahead of Australia with that, and yet we've fallen behind on affirmative consent. Um, so affirmative consent, as I said, can mean different things in different jurisdictions, and that gives rise to an issue of miscommunication, particularly when it comes to advocacy and reform. So, for example, when Victoria was reforming their consent law in 2007, as Rachel referred to, you had people saying the reforms went too far; they went further than required to achieve affirmative consent. You had people saying they didn't go far enough to achieve affirmative consent, and you had people saying this is what affirmative consent is. So, but it's really that spirit of yes means yes, consent must be communicated, which is what all of these different jurisdictions are trying to achieve. Going back to the mens rea, the fault element as it's known, the guilty mind, it's a really important clarification that these changes that we're proposing do not in any way switch the burden of proof. Would never suggest doing that. Presumption of innocence is the hallmark of our criminal justice system, and because we have the presumption of innocence, the Crown has to prove that a crime has taken place. So there has been some confusion there. So we had major political parties putting out tweets and things saying this is going to shift the onus onto the accused to prove consent was given and then having to backtrack. Absolutely not what we're proposing. What these changes would do is instead, it does shift a burden in sexual encounters, right? It requires you to actually, rather than putting a burden on people who aren't consenting to resist and to show non-consent, the law reflects this obligation to communicate about consent. So what does that mean at trial? Well, at trial, it would mean that if the Crown couldn't show that the complainant was passive and did not do or say anything to communicate for consent, that would mean that legally there was no consent. You can't argue, well, maybe internally she was going along with it because she should have fought harder if that's not true. And then related to that with the mens rea reform, it's not that the defense need to prove the defendant communicated. It's that the Crown need to prove the defendant did not take steps to ascertain consent. And that is a part of the piece of the puzzle in terms of proving the mens rea element. It directly directs juries to take into account, did the defendant do or say anything to communicate, to ascertain. Um, but again, the burden of proof is always on the prosecution. It shifts the needle in terms of, well, what are we interested in terms of what was said and done? Where is the focus going to be? There's more of a focus in affirmative consent on whether what the defendant did or said, as opposed to whether the complainant, adequately communicated non-consent.
Thanks, Anna. That's a really helpful clarification. Melanie, speaking of concerns that people might have, people might be concerned about criminalizing well-meaning behavior, but people not being sure what the law is or what consent looks like. How can we make sure that people, and especially young people, have the skills to make sure that they are actually engaging in consensual sexual activity? And I'm just going to add to that, but in a way that is still that aligns with what they want to be doing, right? So we are not, for example, telling them which words to use when they're communicating. You're still on mute, Melanie.
Sorry, I also got a note that my internet is unstable, so let's hope I stick in. I think there's two things here. One is around criminalizing the well-meaning behavior, and the other one is about skills. I just want to touch on the criminalizing well-meaning behavior briefly, although I'm sure that Anna and Rachel can probably speak in more detail to it. But that just isn't something that's happened in other jurisdictions. And I think that I think we need to be cautious that while a change in consent law to affirmative consent is something that I think we absolutely should be doing, it isn't the silver bullet that's going to solve the problem. And so we're not going to all of a sudden open the floodgates to a massive amount of convictions by making this change. And in part, the reason for that is in the response to the answer to your question around making sure that people and young people in particular have the skills that are required for engaging in consensual sexual activity. And this is a really common question and a really important question. But I think because underlying that question is an assumption, and an assumption that sexual violence is the result of people not having the skills or not having the knowledge. And that sexual violence then is the result of a lack of knowing how to communicate about consent. And I think that is not an accurate assumption. So I've been studying consent now for over 25 years. So I started in 2000, talking to people about I asked them a lot about how they understood their partner's willingness. And I used that word willingness intentionally because consent, especially at the time, was not in the public lexicon. And it was not something, and it was very much tied to the legal realm. And so 25 years ago, when I asked people, and I did ask them about consent, I got very truncated answers. And people clearly didn't have a knowledge about what consent was, even consistent with the law. So I'd get answers like when the girl doesn't say no, or if one person's really drunk, then that's not consent. But really kind of, I guess if you take it as a result of willingness, you would think these people need a lot of education because they did not understand law and consent. But when I asked them how their partners indicated willingness, their answers were far more sophisticated. They were far more discussion about, some men would say if there's a hesitation, even for a slight moment, and they would look for just responses and active communication. And so I think if I think back to those people 20 years ago, before consent education was really kind of blossoming, they demonstrated a fair bit of knowledge about how to ascertain whether someone was willing to have sex with them. And really, that's what this is about. And so I think there's a real conflation between this word consent and their partner's willingness. And young people I talk to today are far more sophisticated with their understanding of consent. And I think the whole emphasis on consent in education has actually, in some ways, created a bit of a problem because young people don't believe they know. When there's a lot of good research out there that shows that we agree and decline or refuse sex in the same ways that we agree and decline or refuse other types of social invitations. And so that knowledge is not some vast kind of secret thing that young people need to be kind of shown and kind of unveiled. They have access to relevant knowledge already, and I think we need to work with them to build and understand that kind of knowledge. Um, and so the other um, And so, in terms of thinking skills and literacy, I think Marty Wilson, who's an Australian who did her PhD a number of years ago, her book came out a couple of years ago called Everyday Coercion. And she was interviewing young heterosexual people about their experiences of heterosexual coercion, specifically where men were coercing women. And what really struck me about a lot of the stories that she has in her PhD was the ways in which consent norms and consent skills and practices were being used in coercion. So a lot of the stories would include things like open and honest discussions about, where women would say, well, yes, I'll go home with you, but I'm not having sex tonight. Here's what I'm willing to do. Here's what I'm not willing to do. And the response from the guy was like, oh, yes, yes, no, that's all good and that's fine. But it was almost like a bait and switch, where then often when they would get alone and isolated, then the same course of tactics were being used as what we saw 25, 30 years ago in terms of the kinds of pressure, accusations of teasing, or of course you wanted, or those kinds of things. And um, so I think it's not so much skills. If I think about the skills that young people need, is to actually, what's underneath all of that are the social norms that kind of, or the myths or the cultural scaffolding of rape, as Nicola Gatti would say, that really uphold sexual violence and allow it to happen. Ideas about masculinity, about femininity. And so the skills that are needed is actually skills around how for young people to kind of look under the veil and see what's really there and be able to critique and criticize that and understand that in some ways they're lies, right? That they're believing about sex and sexuality, that men want sex all the time, or that women will say no when they mean yes. And those are kind of really blunt examples. But those are the skills, I think, that if we're serious about preventing sexual violence, that we need to foster in young people.
Thanks, Melanie. That's really, really valuable. And I was thinking as you were speaking about the two kind of shifts in norms that we're seeing, and in a what I would describe as a positive direction towards much more kind of open communication and sort of a move to that yes means yes model that's been taking place over time. And the other is, of course, the rise of the manosphere and, some
Mm,
really kind of toxic norms that are creeping out there. And so people,
yeah,
and especially young people, are having to navigate both of those things. They sort of understand one thing and then are experiencing another. So I like that way that you described, kind of looking under the hood of what they're hearing through the lens of what they are also hearing, and
exactly.
sort of picking that path.
Yeah.
Um, Rachel, moving to you, Anna mentioned some of the pushback around Victoria's law changes being going too far or not far enough. As this change has been taking place in Australian states and territories over time, have there been kind of other arguments, or have there been sort of cases where these issues have been tested, and what's been kind of done to address the concerns that people have been raising?
Yeah. Uh, so there's definitely been concern and pushback, and I think the ideas that again the others have both just flagged in their responses are what we've seen in Australia, and that's been pretty consistent, I would say, across jurisdictions. They sort of the same argument pops up again. Um, and I think first, I mean, and I also think there's critiques on both sides of the issue. I think firstly that um, many critics are right to say that the criminal law is not going to fix sexual violence or end sexual violence. Um, and affirmative consent can't do that. Uh, and I think, contextualizing the role of affirmative consent as being about removing legal barriers um, that make accountability unique in sexual assault cases. Um, is important and that yeah, criminalization is in as an end in itself is not going to get us out of the crisis of sexual violence that we're in. As Anna said, like critics certainly did argue that affirmative consent would, um, actually, sorry, this might have been Melanie, would criminalize spontaneous sexual encounters and ruin intimacy. Um, and that those critiques are typically framed around we're going to need a script or a contract or formal verbal agreement. Um, and I think in terms of responding to that. The law does that pretty well by being clear that using language like say or do anything. Does a person say or do anything to indicate consent? And what does the accused say or do to ascertain consent? Facilitating both verbal and non-verbal communication. And then also that the rhetoric here is um, about emphasizing mutual participation and mutual communication and mutual engagement in a sexual act. Um, and I think then it was Anna that said around, the pushback around proof and evidence, and the burden of proof in particular. I think, what affirmative consent does is clarify the normative expectations of what lawful sexual conduct and really responsible sexual citizenship looks like, particularly around that issue of knowledge of non-consent. And it just makes it clear that silence, passivity, or freezing cannot be treated as consent, which is already a position that's very well supported by trauma research and long accepted outside of the criminal law. So the focus of affirmative consent is, it remains on conduct. What did the accused say or do, or what did they fail to say or do? And that's conceptually consistent with criminal responsibility. It reduces reliance on rape myths and stereotypes about a victim's behavior, which we know have historically been, you know, the norm in decision making, but that they've distorted fact finding rather than enhancing or enabling fact finding in sexual offence matters. Um, and so I think particularly those last two critiques, have been really significant in shaping how affirmative consent has been legislated across Australian jurisdictions where it has been legislated, acknowledging there are still jurisdictions with a ways to go and with recommendations that perhaps I would say probably don't go far enough to use that language, and there is complexity around that, and remembering too that what we're trying to do is squish a social idea, a social theory into a legal framework, and that process is proving challenging. Um, but those are pretty unsurprising critiques. Affirmative consent is changing something about a really powerful institution. Um, it shifts focus away from survivors who are mostly women, and onto perpetrators who are mostly men. And that is really central for rape justice, I suppose, for individuals, but society. But in saying that, it's also not a panacea. It is not going to fix or completely change the way the system causes harm to victim survivors. But I think it's absolutely a monumental step on the way to changing. Um, but I think, keeping in view that, and as Melanie said, like this has been the law in Canada since the 90s, the early 90s. We are, you know, Australia and New Zealand are behind the times in relation to that. But we've not seen the sky fall down in jurisdictions that have been operating this forever. So a lot of these critiques, I think, are the system trying to protect its own interest in maintaining status quo. But there's no evidence that they are borne out.
Thanks, Rachel. That's really useful. And as I say, it's so valuable to be able to learn from jurisdictions that have gone ahead of us. It's not great to be lagging behind, but at least that means that we can kind of look around at what's happening elsewhere and be reassured that the sky is not going to fall, because none of us have any interest in locking up innocent people, right? That's not what we're trying to do here. Um, Melanie, I'm going to come back to you because we know that rainbow and Takatapui or LGBTQIA plus people face much higher rates of sexual violence, and some of your research has looked into issues of sexual harm and consent for members of those communities. Would consent law reform make a difference for those communities?
I think yes, in ways similar to what I was talking about generally before, and I think um, that the information that's specific to rainbow communities, it'd be more they might have particular social norms uh, and understandings and beliefs that are specific to the communities that also need to be kind of addressed and engaged with. And it's also important to kind of point out that those higher rates of sexual violence doesn't necessarily mean that the violence occurs, all of that violence occurs within the community, right? So, for example, lesbian women are still more likely to be sexually assaulted by men rather than their female partners. And so we need to really understand the cause of sexual violence in those communities. One of the things that I hear most actually is slightly outside the topic for today's webinar, but that would make a really meaningful difference would be to remove the sex-specific language of the rape law. And I know that's not what we're talking about today. And Anna mentioned that there are calls to make other changes as well, but that's often something that students, the fact that it's about penis penetrating genitalia as a definition of rape, that not just rainbow students, but all my students are quite shocked by that. And that I think that would probably be the biggest legal change specific would be to recognize a bit more some of the other experiences, not just of rainbow communities, but of other people as well. Although that's a whole other kettle of fish. I'm aware of the time, so I think I'll leave it there so we've got time for questions.
Thanks, Melanie. And I have to say, as someone who was new to this area when I came on board to project manage our report last year, that was one of the things that shocked me too, was actually looking at the law and seeing that that was what it said. I had not realized that, and it seems like a vestige of some past time. So very much noted. We're going to move to Q&A from our audience now. I see there have been a few questions go into the chat. If you've popped a question into the chat and not into the Q&A, if you could make sure that it's in the Q&A box at the bottom of your screen, that would be great. I'm just going to pop that up and I will do my best to direct those to the people they make most sense to. And there's a couple of questions about education and the RSE curriculum updates that have taken place or are in the process of taking place. I know consent has come up quite a bit in those conversations. Whether or not we change the law, I guess there are some improvements that could be made to that curriculum. But would any of you like to speak to the question of education for, I guess, primary and secondary age people, particularly when it comes to consent and whether a law change would be important here?
I think Melanie's probably the expert on education here, but from a more legal perspective, I think the point that Melanie made earlier about unacknowledged rape is really important. So when we talk about education and thinking about how, sometimes law changes like this are sort of dismissed as mere symbolism, and, we're all being really clear that this isn't a silver bullet or a panacea. And if you want to be really cynical, is this just going to change the defense script? But there's something to be said for having a very clear definition that we can point to, that anyone can look up, um, and that will be really useful for education in primary and high school, for all of the public education that's happening out there to actually be accurate. There's really good education happening, but it glosses over the fact that our law does still allow you to make assumptions sometimes about whether someone's consenting. And it ties into a really important point, as I said, Melanie made about unacknowledged rape, and the impact of people themselves being able to look at a definition and say, actually, yeah, I didn't say no, but I didn't say yes. And the law is really clear about what that means.
Yeah, I agree with Anna. And to follow that up, um, I think there's scope to improve consent education. I'm always a bit nervous when people talk so much about consent education because that's not what's going to create the change. And I think it's a useful part of a much bigger picture. And I think what's more important is actually interrogating and kind of undoing a lot of those social norms that support sexual violence in particular. Otherwise, a language change is not enough on its own.
Yeah, I would say in the Australian context too, that there's sort of a little bit of pushback around this language of consent education as being really narrow. And also, and forgetting about the fact that also rape happens because people, because of, you know, gender inequality, because they don't care whether their partner or their potential sexual partner is consenting or not. So, consent education alone doesn't challenge those attitudes and beliefs that underpin those behaviors. And also, we need whole of community, cradle to grave responses. And I think the risk of this hyper focus on consent education is that we make sexual violence a young people problem, but it's actually a problem that a legacy that we have left. So I think keeping in mind that when we talk about education, we need to be talking about people across the lifespan, and that people in nursing homes are experiencing sexual violence as well as young people. So how are we going to address violence that's happening to these other people who often don't have a voice?
Thanks, Rachel. That's a really powerful point. For those who are interested in a little bit more on education, we didn't set out to have a separate section on education in our Addressing Sexual Violence report, but it was such a strong theme, and not to negate anything that any of our speakers have said about the importance of consent education, but throughout the engagement that we had on all of the topics that we looked at in the project, the really strong theme was you can change laws, you can change policies, but if you don't change people's mindsets and behaviors, then all you're doing is locking people up. But that's not what we're going for. We're going for behavioral change, and so we didn't delve deeply into education across all of the areas we looked at, but we did carve off a sort of separate chapter in the report that talks about the need, as Rachel says, for sort of for school, but also community education focused on a range of issues, including healthy relationships and, not just the specific question of consent, but how do we interact with each other? There's quite a bit in there about online safety because of that was another focus of our report, and a bit more about sort of better training for parents and educators and professionals as well. So people are welcome to take a look at that. Moving to another question now. Question here from Kate about whether similar jurisdictions have looked at affirmative consent through the lens of disability, and whether in terms of law you think there are specific issues for the disabled community that need consideration. Have other jurisdictions made specific changes to law to address any issues relating to disabled people? And I know we talked a little bit about that in terms of the way that people can or can't communicate about consent. I don't know if you or anyone else would like to comment on that.
Yeah, I guess just as a starting point, I would note that the Crimes Act does already acknowledge that um, there are some people who may not be capable of consenting due to an impairment, but I don't think that's the focus of this question. The focus is more on, different ways of communicating and so on. Um, so yeah, I'd be really interested to particularly hear from Rachel about, how disability has come up in the conversations around reform in the Australian context. I think what we're setting out to do with this report was to focus on sort of the minimum, like the floor of what we think needs to happen in terms of moving to affirmative consent. And there are certainly other changes and more scaffolding that can be done to support particular communities, particularly, when we start to think about the trickle down effect of law change and changing the way people, think and talk and engage with the concept of consent.
Did you just pass to me, Anna? um, look, I think that's a really great question, and probably one that, well, it's certainly one that a conversation that's happening in Australia at the moment. Particularly, we just had this big review of justice responses to sexual violence, which are meant to be transformative, and um, it really wasn't. It was problematic, but the good part of that process is that it has given space for these conversations to be had. Um, I think in terms of disability, the consent law reforms specifically addressed um, in New South Wales included a provision that would only apply for an accused who had a cognitive or, and I'm just trying to get the legislation up so I could get the language correct, but cognitive impairment or a mental health impairment, and that impairment was a substantial cause of the person not doing or saying anything to ascertain consent. That would then, I suppose, remove the requirement for them to take steps. That's been criticised in some spaces around whether or not that's necessary, but and also the fact that disability was really limited. The discussion around disability was limited in terms of focusing on cognitive impairment and only in relation to people accused of offences. Um, so I think there probably hasn't been an adequate conversation about this, to be frank, and it's one that we have to continue. The other thing I want to add, which is about the gender neutral rape law, like I think this is everywhere in Australia has gender neutral rape law at this time. I didn't realize New Zealand still had that, so I'm just adding to the shock of and surprise on that. Um, yeah.
Finding my mute button. Um, Thank you. All that's really helpful. I've got a question here about what are the steps to start breaking down those social norms that allow sexual violence? That's a huge question. Would anyone, perhaps Melanie, because you've been talking about that a little bit, like to take that on?
Yeah, sure. I certainly don't have the magic answer, but I can speak a little bit about some of the directions that we've been changing or we've been taking. Many people might remember Mates and Dates, which was a countrywide program designed by ACC for sexual violence prevention, and that was pulled in 2022. And one of the reasons that it was pulled is because there was a recognition that that type of programming and that type of education was not enough. That the program would go into schools and it could be the most fantastic program with the most fantastic facilitators, and it can go into schools and do this great work with students and challenge their ideas and all sorts of things and then leave. And then when they leave, it's just everybody goes back to their normal everyday thing, right? The students are still immersed in the school environment, are still immersed in home and community environments where all the messages are the same. And so instead, prevention has been shifted to looking more at a systems approach and to looking more at changing whole systems. And so that basically, and that I've done some work here at the university, and what I always say is persistent and consistent messaging, persistent and consistent kind of approaches involving whole of communities. It's not enough to just provide high school students with a workshop. It's not that providing high school students with a workshop is a bad idea, but it's not nearly enough. And so we're starting to kind of look more at community mobilization forms of change and change in terms of institutional change, where it really is across all levels at the institution. So at the university, looking at policies, looking at education, looking at staff, at students. In schools, I'm working right now with 4 Dunedin high schools. We have a community of practice, and we're engaging with staff, with students, with parents, with governance of the schools, because this kind of change, it's really fundamental, sustained social change is going to take a movement, right? And we have that movement, like the movement is there. And so I think as educators, what we can do is work to bolster that movement, and to better kind of support it.
Thanks, Melanie. That's a great answer to what I said, as I said, a huge question. There's a much more specific question, which I thought was a really interesting one about whether any of you are aware of research that links cancer rates in Māori women to sexual harm and the way that that might affect them getting checked for, I presume, specifically cervical cancer. Whereas that might not be in anyone's sphere of expertise. But if anyone is aware of any research like that, then feel free to raise your hand and direct us in the right place. Doesn't sound like it. Yeah.
It's not my area specifically, but I do know there is research out there that supports the idea that victim survivors may be resistant to medical care. Um, so there is stuff, and I can have a look later and see if I can find something.
That would be great. And if the person who asked the question, sorry, I've dropped the Q&A down now, so I can't remember who it was, wants to reach out to the foundation via our contact address, then if Rachel finds anything, then we can point you in the right direction. It's seems to me to be quite a logical connection, but if we can find some research to back it up, then we'll certainly pass that on.
Yeah, there is. I noticed a comment in the chat about sex, not about cancer and colonization, and I think with a link, and so that might be helpful
Okay, great.
to have a look at.
See that. Excellent. Well, that might well have answered the question, which is great. And we're going to have to finish up there. Thank you so much to all 3 of you for those incredibly knowledgeable contributions to this conversation. It is a really important conversation, as we've discussed. It's not the only conversation by any means that needs to be happening around sexual violence and ways to have healthy sexual interactions. But I think it is a really, the specific law change that we're proposing is an important one and one that has been proven in other countries to work and make sense. Thank you also to our audience today and to those who participated in the Q&A and the chat. It's always great to see people interacting with each other in the chat as well. So if you want to dive deeper, if anyone's got further questions, our report is available on our website, and the researchers also provided even more detailed literature reviews, which are also available on that same website if anyone wants to dig further into the research. And of course, all 3 of our panelists today have extensive research backgrounds themselves, which you can find on their university websites. So thank you all again, and enjoy the rest of your day.